going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Welcome to the show. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, the INREM podcast, make sure to follow us and give us a like. You can find us on Facebook, and you can find us on YouTube, as well as Twitter, or now known as X. You can find us at INREM Podcast. That is at INREM Podcast. If you like, in addition to watching the show, if you prefer to listen to the show just by audio, you can find us on two platforms. You can find us on Spotify, but you can also now find us on Apple Podcasts. Make sure to find us there. Leave us a review and give us a 5-star review. We'd really appreciate it. It helps us grow the show there. But it gives you another avenue to listen to the show without having to be at a computer. With that, we're going to turn it over to Sean, who has our legal update.
Thank you, Andy. So our legal update today, we're back on the What If series. And so the what if question for today is, what if one spouse dies and the surviving spouse wants to sell the real estate? Is a probate required? And the answer is, it depends. And it depends upon how they held title and whether or not they properly accepted the title in that way when they first acquired the property. So in Arizona, there are three main ways that you can hold title as a husband and wife. So the first and most common is community property with right of survivorship. The second is joint tenants with right of survivorship. And then the third is tenants in common. So community property with right of survivorship and the language right of survivorship means that if one spouse dies, the property automatically conveys or goes to the other spouse. All that you have to do is record the deceased spouse death certificate, and then the surviving spouse then owns the property. No probate is required. Now, joint tenancy with right of survivorship is a similar thing, except the spouses aren't holding the property as community property. They're holding it as joint tenants, which means that there's certain community property rules that will not apply to their ownership, and meaning one spouse could convey their interest in the property without the other spouse's approval, etc., versus community property. You can't do that. So that's really the main difference. But some spouses choose for different reasons to hold property as joint tenants with right of survivorship. Once again, you have the right of survivorship language, which means that if the one spouse dies, the title to the property automatically transfers to the surviving spouse. All you have to do is record a death certificate. Now, I mentioned before that there has to be you have to accept the proper title to the property or proper ownership. So there's a period in time where our statutes in Arizona were amended that basically state that, hey, if you're going to take title as community property with right of survivorship or as joint tenants with right of survivorship, you have to have an acceptance of that. You have to sign basically a document that says, yes, we understand this is how we're taking title and we're accepting title in this way. And without that acceptance, you may not have the right of survivorship, or you may not own it as community property with right of survivorship or joint tenancy with right of survivorship. Instead, you will own it in the third category, which is tenants in common. And what tenants in common mean is that each owner owns a 1/2 undivided interest in the property, but no right of survivorship, which means that if one spouse dies or one owner dies, the property doesn't automatically convey to the other owner. They own it basically separately, with the right to fully possess and use and utilize the property as their own, along with the other owner or co-owner, but they don't have the survivorship rights. So in that case, if a husband and wife do own the property as tenants in common, which we do see from time to time, and one spouse dies, it doesn't automatically transfer to the surviving spouse. In that case, the spouse who passed away, the deceased spouse, their interest in the property will have to be probated, or there's also an expedited way to transfer it using an affidavit of succession if certain things are met, such as the value of their interest in the property is below 100,000 and they've been deceased for over 6 months, and there's a few other requirements. You could potentially transfer it with an affidavit of succession, which is approved by the probate court, but it's actually not a probate proceeding. But if those things aren't met, or you want to just transfer it in quicker than 6 months, within the 6 months from the date that the spouse passed away, then you're going to have to go and do a probate with the superior court and open a probate proceeding, have a personal representative appointed, and then they can convey the property to whoever the rightful beneficiary is, which many times will be the surviving spouse, but it's not a guarantee. It depends upon whether the deceased spouse had a will, whether they died intestate, whether they had children from another relationship. All of those things will factor into whether or not that property will eventually end up or their share of the property will end up with the surviving spouse. So that's what happens if one spouse passes away and the other spouse wants to then sell the property.
All right. Thank you, Sean. A few updates for the listener. Keep in mind and keeping your sights every Wednesday at 5 p.m. So tomorrow evening at 5 p.m. Arizona time, we have the Creative Finance Collective. What is that? It is a membership of attorneys and professionals in the creative finance space, not just here in Arizona, but all over the country. We invite a group of lawyers to come on and discuss with us all things related to creative finance, and they bring to that their perspectives on what they're dealing with and the nuances of creative finance as it pertains to them in their given state. So we've spoken just by example with attorneys and had discussions with attorneys from Texas, from Alabama, from Georgia, from Ohio, from California, so we're talking with folks that are seeing this from all over the place. And what's really neat and what's really an awesome opportunity for you, the listener, the real estate investor, is we make all of the lawyers, the members of the collective, available for questions the entire hour. That is just an enormous opportunity for you to ask your question, ask and see what they're doing, maybe get some direction to an attorney in your state if you're looking for one. A lot of these lawyers have good referrals throughout the country so that you can get your specific issue as it pertains to your specific facts answered. But it's really just a really neat opportunity for lawyers and for real estate investors to participate in a talking shop, so to speak, of creative finance. So we'd encourage you to be a part of that. Again, the entire hour is open for questions. We're checking the comments. We're watching them. We're bringing you in. And it's not uncommon to take a lot of follow-up questions from folks that pose them. So make sure that you're a part of that. Again, that is tomorrow, Wednesday at 5 p.m. You can find that in 3 different places: Twitter, YouTube, and Facebook. We run that through all of our channels, and we run it live. So make sure to be a part of that. In addition, today, we're taking questions in the final 15 minutes. So we want you to raise any questions that you have as we discuss our topic at hand. I'm going to turn it over to Mayu, who can explain to you how to go about asking your questions.
Thank you, Andy. So today is August 15th. You are watching the InRem podcast live. Thank you, everyone, for joining us today. If you've been with us on the show before, you know that Andy and Sean and our guests do take questions live on the show. Wherever you're watching from, whether it's from the live Facebook or YouTube pages, we do see your comments live and we are monitoring the chats for your questions. We take questions in order of priority, so don't wait. If you have a great question in mind related to today's topic, make sure to leave it in the comments and we'll try to get to all the questions at the end of the show. So that's enough from me. So let's get into today's topic.
All right. Thank you, Mayu. All right. So when you arrived on the show today, you saw a description of a topic that we were going to discuss relating to taxes for real estate investor and all things related to taxation. It's a good topic. We've addressed portions of that in the past and want to do it again. Unfortunately, due to some technical difficulties with our guest, we've had to make a change, which is the way things go in a live show. So instead of talking about taxes today, we're going to move the topic from a topic we were going to address in a couple weeks, actually, at the end of our season here, and just move that forward. And that is the topic of getting strategic and knowing how to remove wrongful liens and judgments against your property. So one big barrier to the closing table for you as the real estate investor is good, clean title. Oftentimes it works out and there's not an issue. But if you've ever been a part of that percentage of people who have been through the escrow process and found out that there is a cloud on your title or there's a lien, whether it's a valid lien or an invalid lien, judgments pertaining to the seller, you know now what that, or may know now what that looks like to get those removed. As attorneys who have been hired in multiple different ways in how to address these issues, sometimes addressing them can happen quick and sometimes addressing them cannot happen quick. So what we wanted to do is devote an entire episode to that process, in our experience, what that process looks like, what you need to look out for as part of that. So in doing so, we wanted to lay a little bit of groundwork. And obviously, Sean and I are Arizona attorneys, so we can speak specifically to Arizona. It's more difficult for us to speak as specifically. We can't speak as specifically to other states, but there are some general principles that you're going to find to be true in a lot of different places. And in laying the groundwork, we want you as the real estate investor to understand where and how some of these wrongful liens take place, what are wrongful liens, what they look like, and then go through what it looks like to remove them. But Sean, I think that one thing most people don't appreciate, I certainly didn't. They didn't teach this to me in law school. You don't really appreciate this until you're in the process. But most people don't appreciate how easy it is to record a document in the public records in a manner that impacts another person's real estate, whether intentional or unintentional. And I think that's kind of worthwhile to focus on early on in this discussion, is what that process is and just how easy it is. What do you think about that?
Yeah, exactly, Andy. And some states, some counties are going to be stricter than others as far as filtering the documents and things that are being recorded. But for the most part, the recorder's office is very similar to a court, which is somebody shows up with a properly notarized document. Generally and that's pretty uniform across the country, that you have to have the document acknowledged or notarized in order to record it. And you have to have the original, although that's changed a little bit with electronic recording, but you have to have the original. And you can go to the recorder's office and you present the document and say, I want to record this. And similar to the court, there's nobody there who's looking at the document saying, well, this is valid or invalid or otherwise. They look at it and say, okay, is it the original? And is it notarized? Yep. Thank you. We'll take it. We'll record it. You pay your $30 fee and they put a number on it and it's indexed and it's in the public record.
Yeah, we had
a
our guest, Michael Gross, if you recall, he used the analogy, which I thought was helpful in the court context, but used the analogy of there's no traffic cop at the court. when you go to file a complaint and when you go to file a lawsuit, checking it, making sure this is valid. It's the process afterwards that works through all that. But there's no traffic cop at the front. And just like in the recording process, there's not a traffic cop making sure what you're recording is in any way valid, right?
Correct. That's exactly right. And even more interesting is here in the state of Arizona, once a document is recorded, it is always recorded. So there was a case a number of years ago where a party went into court and said, hey, judge, this was wrongfully recorded, should have never been recorded against my real estate. There was no basis to record it. We want not only for you to find it invalid, but we want you to order the recorder to remove it from its record so nobody searching can find this document ever again. And the court entered that order. And the recorder, the county, intervened and said, we can't do that. That's impossible. You can't make that order. Once it's recorded, it's always recorded. And they went up to the Court of Appeals here in Arizona, and the Court of Appeals said, yeah, once it's recorded, it's recorded. Now the court can determine it to be invalid and unenforceable and stuff, but it's still public record and it's still out there, even if it was wrongful from the beginning and should have never been recorded. There is no removing it from the public record. It is always within the public realm and visible upon a search, of that property, and they can see it in the title history to that property.
Which is why, and we'll get to this, why oftentimes, well, not oftentimes, we're always the remedy to fix an improperly recorded document or a document that's creating some sort of invalid cloud on title to your property. The remedy is always the recording of something new, declaring it to otherwise be invalid. Usually some sort of, that could be anything from a release by the party who originally recorded it to, a judgment from a court. But what a title company or the public is looking for is some new subsequently recorded document recording it. But what we wanted to illustrate here, just how easy it is to create clouds on title, given the scope of everything. We joke about this, but somebody could conceivably photocopy their rear end, notarize it, put your legal description on it, and record it in the county recorder's office. And a title company may look at that and be like, we're not going to insure around that. That's a problem. You have to get that fixed. So Andy,
we've seen this happen. We've seen this happen where our client has come to us and said, I'm no longer showing as the owner of my property, and there's this warranty deed that's been recorded and it's been notarized, but that's not my signature, and I don't know how they notarized that. And so we've then gone and, basically subpoenaed the notary and the notary book, because the notaries have to have a book, and that signature was not in the book. There was no record of our client having notarized it. And so we ended up looking at the stuff around that same date that was in the book, and we did a title search, and then we matched up the notary signature on our client's purported deed with the notary signature on another deed that notary actually did do. And it was identical. The spacing was identical. Everything was identical and lined up. So they photoshopped the notary block and recorded it. And it looked like basically our client conveyed the property to this individual when they didn't. That's real estate fraud, and it's a real thing. And, now there's even processes where you can sign up with the different county recorders and say, hey, if anything's ever recorded against my property, let me know so I can confirm whether or not that was me that actually recorded or not. And you can go and fill that out. But real estate fraud's a real thing, and, something to be aware of.
So, Sean, given what we know and are discussing now about just how easy it is to record a document with your applicable county recorder and create a problem for somebody else's real estate. Let's now jump to discussing when that creates a cloud on title and what that is when that happens, and the difference between that and what we as lawyers would call a lien. What is the difference between a lien and just an encroachment or cloud on title?
Yeah, so and that's a great topic, because a lot of times the lingo that we hear in the investor community, always anything that's recorded is a lien, right? And that's not true. A lien has a very specific legal definition, which basically a lien is any document that is recorded to secure the repayment of an underlying debt. That's a lien. So, an example would be mechanics liens. Somebody, does work on your property, they're owed money, they record a mechanics lien. A deed of trust, that secures the payment of an underlying promissory note. That's a lien. A mortgage is a lien against real estate. So there's judgments that are recorded for payment of money. Those act as liens against real estate. So a lien is anything that's recorded for the purposes of securing an underlying debt. A cloud is anything that impacts the marketability or insurability of the property. So the best example is found in a recent court case here in Arizona of distinguishing between these things, where it was in a HOA community, and the HOA kept levying fines against an owner within the community for the way that they were maintaining, that owner was maintaining her property. And so that owner decided to go around to all the board members, the HOA board members, and review their properties and see if they complied with the CC&Rs. And then she would find things with their properties that she didn't think complied with the CC&Rs, and she would record notice of CC&R violations against their property, saying their property is not in compliance with the CC&Rs. Once again, there is no gatekeeper at the county recorder's office, right? So she's filling out these notice of CC&R violations, having it notarized and filing it, paying her $30 and filing it with the county recorder's office. Well, then of course these board members go to sell their property, and what shows up? Notice of CC&R violation. The title company is like, well, we can't sell because that is a cloud on title. So the board members, a few of them, filed a lawsuit under ARS 33-420, which special action removal, which is an expedited removal of liens, claims, and encumbrances against real estate. And then also to seek damages based upon a wrongfully recorded lien, claim, or encumbrance. And the bad actor, for lack of a better term, she shows up to court and says, hey, they can't pursue this case against me under ARS 33-420 because my recording was neither a lien, claim, or encumbrance. It was simply a notice of violation. And the court ruled in her favor and dismissed the lawsuit and said, yeah, there is no lien, claim, or encumbrance. And for me to have jurisdiction under ARS 33-420, it has to fall within one of those three categories. This may be a cloud on title, stopping you from being able to sell your property, but it's not a lien, claim, encumbrance. And it goes up to our Court of Appeals, and they affirm, and they can't pursue under 33-420. Now, they could pursue under quiet title. They could seek a declaratory judgment. And there were other avenues of relief. But recording this notice of CC&R declaration is not a lien, claim, or encumbrance. They're not seeking the repayment of a debt. They're not encumbering the property, saying that, I have, some type of interest in the property or that I have a claim against the property. Instead, it's simply a notice of CC&R violation, which, admittedly is a cloud, but it's not a lien, it's not a claimer, it's not an encumbrance. So when you use that verbiage, just understand that, these things have very specific legal meanings. And just because something's a cloud doesn't mean it's a lien, and vice versa. So just keep that in mind. But yes, I mean, and there's special statutes to remove liens as opposed to statutes to remove clouds.
Well, yeah, that's the real world consequence to all this. Is in that case, it impacted the statutory procedure you were allowed to use. And, it's not like real estate investors just get this wrong. It's lawyers get this wrong. Now, to be fair, to the lawyers that went one way, they didn't have the benefit of a court decision deciding or defining things the way that they defined it. But that's important to know, because that's going to dictate your strategy going forward and how to remove the lien, and it's going to save you tons of attorney's fees typically if you get it right versus if you get it wrong. So let's go through some common liens and or encumbrances that are invalid, and what we see and what we do to remove those. So another thing I think's worth noting is when we say an invalid lien or even an invalid encumbrance, that doesn't mean that it was always invalid. You might have a lien that was once invalid that became, by operation of law, by expiration of the statute of limitations, a variety of different things, a lien that is no longer valid because, again, like Sean said, the recorder's office doesn't go delete old material from the public record and it's suddenly gone. It's always theirs. But let's talk about a couple common ones that we see. Sean, I know for some time you almost had to become skilled at this because you ran into so many of these, and the process of getting through it was arduous at first. But let's talk about unrecorded or unreleased deeds of trust that were once valid liens but are no longer valid liens. Talk to us about how that transpires and what you do to remove those.
Yeah, so this is a common problem with servicing transfers and changes. And basically a property is sold and the deed of trust is paid off, but maybe it was in a servicing transfer. Maybe just the servicer wasn't doing the job that they were supposed to do. And, it fell through the cracks and the deed of trust isn't released. And then, they go to sell, the new owner goes to sell the property. And they're like, wait a minute, this old deed of trust that was against it when I bought it and paid it off as part of the purchase, it's still on there. Or maybe they paid it off. Maybe it was a second position lien. They paid it off and they go to sell the property. And so in that case, we're talking about deeds of trust that are, traditional loan deeds of trust, with a servicer that is a large servicer, probably a conventional loan, Fannie Mae, Freddie Mac. But nevertheless, it's just not been released. So what's the process if that happens? So the first step in the process is, and you can't just call them up and be like, hey, this deed of trust didn't get released. Can you release it? Because generally the escrow company and the title company or the client has tried that already before it reaches my desk. And they get the runaround. Oh, we can't find it anymore in our system. Well, yeah, because it was paid off 15 years ago. Like, of course you can't find it in your system. Or, oh no, the servicing transferred on that loan. And go talk to so-and-so. It's like, well, you received the money, so why aren't you releasing? It's what it's like to deal with these lenders sometimes. It's difficult. So when it reaches my desk, my first step is to figure out, okay, who are all the different players that are involved in this? And so you have the holder of the loan, right? So this is the person that actually would have held or owned the loan at the time that the payment was received. Then you have the servicer of the loan, and this is the company that's hired by the lender or the holder of the loan to receive the payments. Now, there could be more than one servicer because, these loans are part of a portfolio. And so even though the loan's paid off, it's still within the portfolio and the servicing transfers. So you could have the servicer at the time it was paid off versus the servicer holding that same portfolio today. And they could be two separate entities. And so you need to figure that out. And then the third is, who's the beneficiary of the deed of trust? So for purposes of being able to securitize these loans, you have MERS, or mortgage electronic registration services or systems. But MERS is this clearinghouse that basically allows you to transfer these notes, the underlying notes and the deeds of trust, without recording an assignment of the deed of trust every time you transfer it. Instead, they just let MERS know, oh, this loan transferred, and then MERS updates the servicer information or the holder information, and they keep track of that. But they're listed as the beneficiary of the deed of trust, which is important because as a beneficiary, you have legal obligations under Arizona and federal law. So I figure out who all these players are, and then you have to send out a certified letter to all of these players and basically say, look, this deed of trust was paid off on or about this date. You had 30 days by statute to release it. Failing to release it entitles my client to actual damages. But we're giving you notice now that if in the next 30 days you don't release it, we don't even have to show actual damages. We get statutory damages. But now 30 days is a long time if you have a sale of real estate, right? A residential sale, because normally, once again, by the time it ends up on my desk, you're 2-3 weeks into escrow, hoping to close in 2 or 3 weeks. And so 30 days is something we don't want. We don't want to have to wait 30 days for them to release. So then I pair that with a payoff demand and say, hey, your deed of trust is still showing a record. And because you haven't released it, you are obligated to provide me with a payoff. Well, the nice thing is in Arizona, payoffs must be delivered within 14 days of a written demand. So now I've taken the 13 days and I've shortened it to 14 and say, hey, give me the payoff in 14 days or you suffer statutory damages as well and attorney's fees for failing to provide this payoff within 14 days. I honestly, if they want to give me a payoff of $0, I don't care. The title company will accept that and will close the escrow. So if you want to actually provide a payoff, yeah, that's great. Give that to me in 14 days. Or, and I've had this happen, the lender actually comes back and says, oh, we think we're owed money and here's the payoff. Okay, well, we can work with that. At least somebody's taking responsibility for the loan and they're saying they're owed money, and now we can go and say, okay, give us an accounting. Did you not receive this check? What's going on? Why are you claiming you're owed money? But the payoff demand is, in my view, the most critical thing because it's short. It basically cuts in half the time frame to get this release, because most of the time they don't want to give us a payoff, so they're just looking to release the deed of trust. And then, of course, myself or our office is calling and following up with the servicer, with MERS, with the holder, saying, hey, we sent this letter. When are we getting this payoff? When is this coming to us? Oh, we can't find it. It's going to take 45 days. And I don't care that it's going to take 45 days. The statute says 14 that you have to give us a payoff. You chose not to release the deed of trust. So give us the payoff. And we go round and round and round, and knock on wood, 90% of these cases, we get the payoff, not the payoff, we get the release within that 14-day period. And everybody goes on their merry way. And unfortunately, the buyer, seller, whoever's paying our attorney's fees, ends up having to pay us attorney's fees, but it's released and the property can sell and transfer without any further issues. Now, that's when you have a traditional lender or a conventional lender. Things get a little bit more interesting when you have a private lender. Seller carryback is a good example. those regularly are paid off, and the deed of release is not recorded because the private seller doesn't know to record a deed of release.
Right.
It's not like they have processes and systems in place to say, oh yeah, we got paid off, we need to record the deed of release because that's what's required by law. So they get their money, they're all happy, and they're gone. And a lot of times they're no longer even alive when it finally, goes to forward with the sale of the property. And so now you're stuck trying to track down, figure out, is this individual still alive? Where are they? We have to do, we have to do some research, and we have some databases that we use, skip trace them, to basically figure out, their status. If they're alive, then we try to work with them to get the release. If they're deceased, we do have a statute in Arizona that says if all of their heirs, the rightful heirs of their estate, whether by will or by our statutes, if they sign a release of the deed of trust, that's good enough. You can act, even though they weren't the original lender, if the heirs of the estate, so you don't need the personal representative of the estate. So you don't even need a probate to have been opened. As long as you can identify the heirs and get them to sign, they can release. There was one time where we figured out that they were deceased, and they had 3 children that we could see from the skip trace. And one of those children had a published cell phone, and we ended up calling, and they answered. And we said, hey, blah, 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 blah. And we talked to them. And long story short, they contacted their other siblings, and they said, oh, yeah, I was aware of that. That's been paid off. And they were kind enough and gracious enough to work with us. We're all 3 signed, and we got the release done, and the property closed, which was cool, But when I found out they were deceased and they had 3 kids, I'm like, and only one had the published cell phone, I'm thinking, oh boy, how are we going to, and it just worked out. So there's different things you can do. Now, finally, if all of this fails and you're not able to secure the release, but you can prove beyond a shadow of a doubt that that loan has been paid off. Here in Arizona, I'm not sure about other states. In fact, I talked about this on the collective, and other attorneys like, oh my gosh, that's the most amazing thing. We don't have that in our state. But in Arizona, we have a statute that says that if you can show clearly, that it's been paid off, and the beneficiary cannot be found within the county where the property is located or is deceased, and you can provide proof of that, you can file a lawsuit or a complaint, and the court ex parte, which means without even giving notice to the other side, without serving the complaint, the court is empowered, if you can prove the existence of those 2 things, to sign the release. And so we've been able to go into court without even having served the complaint and present the court with a application or a petition to remove the lien, get that in front of the court within, a day or 2 of filing the complaint. And, the judge generally requests a day or 2 to review it. And then they sign the release. So we've, within a week's time, filed the lawsuit and obtained the order releasing the lien, in that short of period. Now, the court's generally going to want to see that you tried to get the release or the payoff or whatever, and you've gone through the processes. But if it's simply not possible, then, at that point, you can go in, at least here in Arizona. Now, other courts, maybe you have to serve, but there's an expedited process where, you can have a hearing or an application for order to show cause why they haven't released that lien, et cetera. But that is the process of getting, deeds of trust released. Things get, even more interesting when the servicer has gone into receivership and you have to work with the FDIC as receiver to release. I've done that before where I've gotten the FDIC to release. I've proved payoffs where the servicer went under by calling, it was a VA loan. I've called the VA, and see, the VA has to keep record of payments on the loan and payoffs, because you can have multiple VA loans. You just can't exceed a certain amount. So you need to know how much, credit you have basically for a loan with the VA. So the VA is always keeping track of the loan balances and stuff. And so I've actually called up the VA and been like, hey, this servicer is not working with us, or they're out of business. I forget, whatever the case was, but I need to prove that the loan's been paid off. Do you have record of that? Oh yeah, we have record of it. Oh, can you send that to me? And they faxed it to me. And sure enough, it showed that the loan's been paid in full and it's been paid off. And so I have a record from, the federal government, the VA, showing that it's been paid off. What more would a court need in that case? A record from the feds showing, the loan's been paid in full, that you can then present to get that release. So there's a lot of interesting things that happen, and it just really depends upon the type of loan, who's servicing it, and you just kind of have to take each one on its own to figure out what the best process is to get it released.
Now, when the market was really hot, and even after the fact, we had this. I don't know that we see it as much now, but for a while we were seeing a lot of investors, wrongfully in our mind, but attempting to lien property that they were in contract with, or to encumber property that they were in contract with, so they didn't lose out on the deal, or so the seller wasn't able to renege and go somewhere else. So they were filing these memorandums of contract. Now we can get into when that's appropriate and when that's not, but is the process to remove those similar to the process you were just explaining in removing a unreleased deed of trust?
No, it's a little bit different. So if you have a wrongfully recorded memorandum, so in Arizona, I'll get back to ARS 33420. It basically says that any document that's recorded against real estate is going to be deemed wrongful and invalid if there was no lawful authority to record it, or it's not authorized by statute. So in order for a document to be recorded by statute, it has to be acknowledged by the party that's being bound by the document, or the party to be charged. And if it's not, then you're technically not supposed to record it by statute, or it's not allowed by statute. But then you can also have legal authority that allows you to record documents, such as a contract can say that one party can notarize a document and record it, and have it act as a encumbrance against real estate. So in that case, the process, if you have someone who's recorded a memorandum that you believe to be invalid, maybe they didn't have legal authority, maybe the contract is terminated, whatever the case may be, and you're seeking the release of that memorandum, the first step in the process is to give them notice that you believe the memorandum is wrongful, and to send a 20-day notice under two statutes, so 33420, and say, hey, you have 30 days or 20 days to remove this. And I would also send a letter under our quiet title statutes also saying you have 20 days to remove that. If they still don't remove it, then a lawsuit will need to be filed. You likely can utilize the special action jurisdiction, because it is a encumbrance or claim against real estate. You're making a claim against real estate via your contract. You're claiming some form of equitable interest in the real estate. And so that gives the court jurisdiction under the special action process, which is an expedited process that allows you to get in front of the court in short order, normally less than 10 days, and bring the other side with you. And they have to explain why they think that their memorandum is valid and enforceable. And then the court sets a expedited discovery and hearing process, and schedules everything out from there if there's a basis to, or at least there's been an explanation as to why it would remain of record. And that's how you go and remove that. There's no like, hey, give us a payoff. Hey, give us this. Hey, give us that. Similar to the deed of trust provisions. There's nothing specifically addressing memorandums. Instead, you would do it under ARS 33420, as well as our quiet title statutes in Arizona.
So I want to shift also to, we've been talking about liens or encumbrances created or are the product of some sort of contractual relationship between parties, either buyer and seller or creditor debtor. And some of these liens could be and encumbrances could be intentionally wrongful. Some of them are just there by mistake. And one thing about Arizona, and this is kind of a side note, but I think it's worth noting, if you're the party on the other side of this deal, which is the one that recorded liens, or did something that encumbers somebody's property, one thing about Arizona law is they like to, before they really harshen the penalties, they like to assume, I think the law tends to assume that the parties maybe made a mistake, and they like to give the parties an opportunity to correct things. So if done right, you've heard Sean talk a number of times about an initial notice might be required here or there before A, B, C, and D can happen. A good point of reference for you, the person who may have recorded the document, if you did this wrongfully, or if you think you did, this is your opportunity out in an inexpensive way oftentimes. Because if you're wrong and you don't take advantage of that, there are times that the law in Arizona especially can then impose the pretty hefty penalties, right? A lot of that time, Sean, it comes right after the notice period.
Right.
So
yeah, that's exactly right. So
go ahead.
Oh, sorry. Yeah, that's exactly right. I mean, there are significant penalties, but like you said, there is an opportunity generally for you to fix the mistake. Really, it's one of those things where, hey, if you review it and it's, wrongfully recorded. I mean, I've had clients execute in quiet title actions where they send the notice with the quitclaim deed. I've had clients execute it. And, when they realize, oh, yeah, I really can't claim an interest in that real estate, and they sign the quitclaim deed. And then the other side's like, well, I want my fees. I'm like, you don't get your fees. That's the whole purpose of the statute, is you give us an opportunity to fix the situation, and everybody goes on their merry way. Here's your quitclaim deed. I'm sorry, but that's the way it goes. And I was right. They didn't get their fees. So
yeah, it always is a surprise when it happens, but yeah, you'll start those quiet title lawsuits and get that one day you'll get, just before you're thinking about getting ready to go, a quitclaim deed in the mail signed, and you're like, well, I guess that was a lot easier than we thought. So yeah, it definitely happens. All right. So then let's jump to the other issues. We're starting to see this more and more. It's a hot topic in the law. You talked about this a little bit ago when we were talking about title fraud, and you gave an example of people just maliciously, trying to just commit blatant fraud and take property. There are cases like that. We also see cases where people maybe aren't intentionally in their head think that they're committing fraud, but they've bought into some convoluted theory that they've read about on the internet. And you know what I'm thinking of? I'm thinking of like the sovereign citizen stuff, where they might, legitimately think they've got a claim or interest in this property because of something they read online. So they start recording who knows what in the county recorder's office, creating all kinds of encumbrances on the property. What do we need to do to deal with that in order to remove those kind of encumbrances against our real estate?
Yeah, it's very similar to removing a memorandum. You basically want to pursue an expedited proceeding. That one, though, it's a little bit more clear cut that it's wrongfully recorded than, say, a memorandum. And so, in that case, statutory damages probably kick in right away, as well as the right to recover attorney's fees. And so, you're likely to just immediately out of the gate file a lawsuit under a special action lawsuit under ARS 33420 here in Arizona, with an application for order to show cause, have the court set a hearing, serve this individual with all the paperwork, including a hearing requiring them to come in about 5 days to the hearing, and you get them served with that and show up. And the few that we've had, they actually the quote unquote sovereign citizen didn't show up, and then the court said, oh, well, they didn't show up, so and they were validly served. They knew about the hearing. Boom, release. And they've released the wrongfully recorded document. And then I also know some counties where this has been going on a regular basis have now the recorder's office has, and the county attorney's office have gotten involved, because it is criminal. It's a misdemeanor, but it is a crime to record documents that to be wrongful. And so, the county attorney's office in at least one of these counties here in Arizona has pursued criminal charges against one of these individuals. And the recorder, I believe, is rejecting the filings as well. So, hopefully stopping this practice. And so, there at times can be a gatekeeper, but, it generally gets to a level of, really damaging just, everyday citizens on a regular basis. Because, even unfortunately, a lay person can't go through and seek this type of special action relief. They likely don't qualify for pro bono legal services. And so they're stuck paying a law firm like ours some money that they shouldn't have to pay to go and release something that was wrongfully recorded against their property. And good luck trying to get a judgment and chase this sovereign citizen around, right? I mean, You're never going to get paid from them. So at the end of the day, it's just damaging, citizens that are just trying to own and sell their homes. And it's unfortunate. And I'm glad that the county where this was happening, that they've become more active in trying to, stop it.
So part of the title to our show today was removing invalid liens and judgments. So let's shift to judgments. And I know there's a variety of different processes and procedures to challenge judgments after they've happened. There can be the question of whether a judgment's valid or invalid, whether services happen and things like that. But I'm assuming what we're talking about here is judgments that are creating a cloud on title, or judgments that have already gotten to the point where they've been recorded against the property. So when we talk about removing judgments, what are we typically talking about here, and what's that process look like to remove a judgment?
So the first question you have to ask is the judgment still valid? So in Arizona, judgments are valid for 10 years unless they're renewed within the 90-day period prior to the expiration of the judgment. So it can't be removed a day after it expires, and it can't be removed on the 91st day before it expires. It has to be renewed within that 90-day period. If it's not renewed, the judgment is expired, and you generally have to work with the title company to remove that from showing up on the title commitment because it's invalid. Now, title companies, they're about mitigating risk. And so some title companies are going to be easier to work with than others on that. And there may be a time where you have to go to the judgment creditor or their attorney and be like, hey, you didn't renew your judgment, it expired. Can you, provide us with a release of this judgment?
So what I think
maybe they won't. Technically, they don't legally have to.
Yeah, what it sounds like you're saying there is there might be title companies that are okay with an explanation that you provide through your counsel that says, look, this judgment's expired. Here's the law. There's no doubt about it. We don't even need to pay any attention to that. There's going to be title companies that might be okay. But there's other title companies, because they're all in business and they're not required to be okay with that might just decide, no, we want more.
Right. Yeah. And then you're having to obtain the release. But honestly, there's no statute or law that requires a judgment creditor to release an expired judgment. I mean, if you're a judgment creditor, you're like, why should I pay my attorney to release something that's already been released by operation of law? Like, what's my duty to do that? I'm not
Now
sure,
there's also no
file a declaratory judgment action.
Yeah. There's also no law requiring you to use that title company either, though, right?
Correct. Yeah. Yeah. So you could always change title companies. And I've seen that where title companies are being difficult about things that clearly the law provides otherwise, where they've said, let's just move title companies to one that's, going to look at the statute and take a more reasonable approach. And it happens. Yeah. So there's no requirement that you use that title company, but assuming the judgment hasn't expired, then you have to ask yourself, okay, is the judgment something that must be paid at close of escrow? And frankly, the only time that a recorded judgment would not need to be paid at close of escrow is if the property that's being sold is the judgment debtor's homestead. So it's in their name or the name of their, family trust, and they're going and they're selling that property, and the proceeds of the sale aren't going to exceed the amount that they're going to put in their pocket from the sale is not going to exceed 400,000. Now that's a significant over the last 2 years. The homestead exemption in Arizona has gone from 150 to 400. Ever since I've practiced, I think it's always been 150, and that's, I don't want to date myself, but that's been a while.
Yeah, it was
I
150
don't remember it ever not being 150. Yeah, and then it went to 250, and then all of a sudden, it within a year, it goes to 400,000. And so, the identifiable proceeds of the sale, if here in Arizona, if it's 400,000 or less, then the title company actually has the ability to record a release of the judgment. However, one caveat is if the judgment debtor upon the sale of the property is going to receive between 300, well, it's 80% of the amount of the judgment. So between 80% to 100% of the exemption amount of the 400,000 exemption. So in this case, it would be 320. If they're going to receive $320,000 up to 400,000, and the title company wants to be able to release the judgment lien, they have to give notice to the judgment creditor and say, hey, this is under escrow. The judgment, here's how much the sales price is, and the judgment debtor is going to receive X amount of dollars from the proceeds of the sale. And the judgment creditor can come in and object. The basis for objecting would be that it's not being sold. It's being sold, say, to a family member or a friend, not for fair market value, those types of things, that it's going to, be a fraudulent transfer or wrongful conveyance or something like that. But if it's an arm's length sale, normally there's not a basis for them to come in and object. But they could potentially, but anything below the 320, or 80% of the amount of the homestead exemption, no notice has to be given, and the title company can then record a release. Or if they wait the 20 days after the notice because it's within that 80 to 100%, they can then record the release as well if the judgment creditor doesn't come in and object. If they come in and object, sales halted, and you have to go to court and have the court figure it out.
Yeah, and I'm going back to the situation I mentioned before about switching title companies. We had recent changes to Arizona law, like Sean said, increasing the homestead exemption amount. And of course, because there's newness to that law, there's appeals happening or it's being challenged and things like that. But I've seen on a couple of occasions, one particular where a title company was they just took a position that didn't really make a whole heck of a lot of sense. But then what it did is, because they required a lot of the stuff, it emboldened the other side that wouldn't have ever asked for any of this, because they knew they weren't entitled to it. But the title company's like, well, maybe this or maybe that. And it was interesting when we just said, you might just have to go find another title company, or you're going to have to fight this, but that's going to be a lot of money and time. You just may find another title company. The second they said that, title company's like, yeah, okay, we're good with it. I was like, okay. So in any event, well, good information. So
Yeah.
go ahead.
Oh, I was just going to say a lot of title companies are struggling with this new law, and that seems to be the play, which is, hey, we're going to be as conservative as possible until you threaten to go elsewhere, and then we're going to start really looking at the law and following it.
Yeah, exactly. Well, everybody, thanks for joining us. That is our show today. Make sure to join us next week. We're going to be talking about strategies in acquiring businesses with investor and entrepreneur Abraham Gray. That should be a good show. Looking forward to that. Make sure to join us, and we'll see you next week. Thanks for being with us.
Have a good day, everyone.